Well, howdy everyone, and thanks for joining us for 10 Steps to Preserving Privilege in Investigations. I'm David Glazer. I'm here with two colleagues, Dulcie Foster and Lucine Hoppy. And we are going to cover, or they especially, are going to cover lots of topics related to privilege. But first, just a few housekeeping things. So, if for any reason you have to go, you will get a recording of today's webinar. One question we get a lot are, what about the slides? Can we get the slides? You should. If you're online right now, you got the email that has the slides in them. So you have a copy of the slides. It's contained in that email. And later this week, you will get a link to the recording. And so if you have to go sign off, or if you think anyone in your organization would like to hear this, you can send them the recording. And just a reminder, the last 4 or 5 years of our webinars are available online for free. You can listen to them, send them to friends. And that just, you can go to if you Google Fredrikson and Byron webinars, it'll take you right there. If the sound goes south today, you can dial in, and Robert will be sending out in the chat box the number you need. If you can stream it, great, but sometimes the internet slows things down. And then last announcement, I don't know for sure what our next topic's going to be, and I don't know for sure the date. It's probably 8/8, which is just a fun day to do everything. And I think the topic is going to be frequently asked questions, which is often our #1 topic of the year. Assuming we do frequently asked questions, or we will either in August or September, feel free, if you've got a question that you would like answered on the webinar, send me an email and just include FAQ in the subject line. I will warn you, if you don't include FAQ in the subject line, the odds of it getting lost in the clutter are high. Put FAQ in the subject line, and we will do those either in August or September, yet to be determined. So now in a minute, I'm going to turn it over to my colleagues, Dulcie and Lucine, who have a number of traits. First, they are amongst the more uniquely named members of Fredrikson and Byron. I work with both Dulcie, Lucine, and then also their colleagues, Kevin Rich and Joe Dixon. We tend to pair up a lot on government investigations in the healthcare world. And so we'll often use someone who's got a little more background in the healthcare arena with someone who's got a little more background in the white-collar arena, where each of us kind of then brings something to the table. And we will hear today, I've learned a bunch of things from these guys. They work for clients big and small, both on internal investigations, sort of you think you've got a problem and that's and you want to figure out if it's real, so how do you do that? And external investigations, the government shows up with their government agents. And so what we're going to talk about today really applies in both of those contexts. So without further ado, Dulcie, I will turn it over to you.
Thank you, David. So as the title slide suggests, today we're talking about preserving privilege in connection with investigations. And we've outlined 10 steps here that are on this slide in our overview of the presentation that we're going to be giving. Before we get started talking about preserving privilege in investigations, I thought it would be helpful for the non-lawyers in the audience to talk about what we mean by privilege. This is a concept that attorneys are generally pretty comfortable with, although I know many lawyers who don't fully understand it, but a little bit less familiar to people who are not lawyers. Privilege is really, it's an idea or a doctrine that applies in court cases when there are subpoenas, when there are government investigations, or any other kind of legal demand for information. Privilege is something that the lawyer may assert to object to producing the document or the information that is sought. And it can be really helpful in an investigation to be sure that privilege is protected, because if you don't have privilege in place, the recipient of the subpoena, you or your company, can be forced to disclose sensitive or confidential information that you really don't want to disclose. And sometimes that information may not have anything to do with the investigation that's involved. So often we'll do an investigation on let's say some sort of healthcare fraud issue, and we'll discover that in the process of investigating that there is a trade secrets theft that's being discussed in some of the emails that are sought that are connected to the investigation, but not what the investigation is about. That may be something that the company or the hospital may want to protect. So that's just an example of why privilege may be important in that context. If privilege applies, though, if it's legally protected under either the attorney-client privilege or the work product doctrine, which is something we'll explain later, then you may have an argument against disclosure in that court proceeding or in connection with that subpoena or demand. So that's what privilege is. And now we'll go to step one.
Actually, before you do that, Dulcie, privilege is there are other kinds of privilege. We're not going to talk today about peer review. But in the healthcare context, especially if you have a medical necessity investigation, peer review will sometimes come up. And it's worthy of a mention in this context just because I will often sloppily refer to a peer review privilege. But it isn't as clear to me that peer review is a protection, but at least in some states, arguably not a privilege. And this is a place where semantics can matter. And one of the reasons, like in Minnesota, it is actually a crime, and this is true of a bunch of states, to release peer review information is a misdemeanor. You could, in theory, get fined or go to jail, not for very long, but for releasing that information. And the reason that becomes an important distinction is that we'll talk a little bit about how you can waive a privilege if you act improperly. If something is, in fact, a protection but not a privilege, it may not be waivable. And so peer review might protect some of the things you do. But like the stuff we're going to talk about, there are often steps you have to take. In peer review, if you include certain non-medical professionals in your process, you can destroy the protection that you would otherwise have. And Dulcie and Lucine will be talking at length about ways you can accidentally screw up your privileges.
Thank you for that clarification, David.
All right, step one in our 10 steps to preserving privilege. First of all, learn the privilege rules, and as a caveat, I would say make sure you teach the privilege rules to all your employees who are involved in internal investigations. The next several slides address this step. And the first thing we wanted to talk about is understanding why preserving privilege is important. There's a number of reasons, and we have several listed up here. Preserving privilege can help limit the legal exposure to the company. This would be both for known and unknown risks. Also, limiting legal exposure to particular employees, as well as protecting from harm for business interests. So you're talking about business disruptions to the company and things like exposure of trade secrets and financial data. Let me give an example to illustrate this point. Say you're doing an internal investigation of accusations of sexual harassment by a leading physician in a cardiology group. The investigation's headed by HR, and HR staff is conducting the investigation. Perhaps some interviewees are accusing the doctor of receiving kickbacks from a device company in the context of these allegations. You find this out. There's an interviewee who's known to be officious. They think that the doctor is deliberately upcoding a commonly performed procedure. And HR has to make some decisions about what to do with this. And a bunch of emails go back and forth discussing the risks of investigating or not investigating these other issues. Well, if you haven't conducted the investigation under privilege, the government or other third parties can have access to all the communications and interview reports surrounding this with all of these other allegations and embarrassing, potentially disruptive and embarrassing details floating around. So that is why it's important.
I want to talk a little bit about when preserving privilege is important. It is important, but I think it would be overstating things to try to say, well, every time you conduct an investigation, every time you look into anything within your company, you must keep it privileged. Privilege does come with a cost, primarily, and the biggest one is that you really can't keep something privileged unless a lawyer is involved somehow in the investigation. Lawyers have to lead the investigation for the investigation to be under privilege. And whether you're talking about an outside attorney like me and Lucine and David, or whether you're talking about an in-house attorney, there's a cost associated with involving a lawyer. Some issues just really aren't serious enough. I've been working with companies for a long time. Many of them have hotlines, and sometimes those hotlines get reports of ridiculous things. I had a client once who had to deal with a report that somebody was stealing lunch out of the office refrigerator. Things like that, just probably you don't need to get a lawyer involved. If it's a routine thing, if it's something like an audit or just something that you're kind of doing on an annual basis, probably not something that you're going to be doing under privilege under most circumstances. This is really kind of more about running the business and making sure that the business is being operated in the way that it should be. I think the main point is before you begin an investigation to assess up front whether it's something that really should be protected under privilege. So here, some of the questions that we would ask when trying to make that call is, is this something that involves a subpoena or a government request for information? If the government is on the outside looking in, you probably should get a lawyer involved, and you probably should consider whether to keep the investigation privileged. Could this end up in the newspaper? Is this something that presents a serious reputational risk to the organization? Privilege can be extremely important under those circumstances. Could somebody go to jail? Is this likely to turn into a lawsuit? All of these are factors that would lean towards keeping something privileged.
So, Dulcie, let me ask you this, and Christine, I'm curious as to your take. So one of the things in the healthcare world we deal with a lot, you do evaluation and management reviews of a physician. You guys are super akin to those. So often those are done annually, right? You're just going to go out, you're going to do a review. We're doing it of every doctor in the shop. So how does that fit into our checklist, right? Should those be done under a privilege?
I guess, my general thought on that, and Lucine may disagree, is that if this is something, again, that's routine, it's something that you're doing every year, this is part of running the business appropriately, probably not something that you would conduct under privilege. However, if you do that routine audit and you discover there are some pretty serious issues with Dr. X, and you need to dig further and do a deeper dive into Dr. X's coding because you're concerned that there may be a really serious Medicare fraud issue involved here, then that's, I think, the point in time that I would say bring in a lawyer and start investigating under privilege.
Mm-hmm. I generally agree with Dulcie. I would say the only other exception I would say would be if there's a doctor has consistently had problems in the past with other things, or if there's some other allegations floating around about a particular doctor, even a routine audit of that doctor you may want to conduct under privilege and get inside or outside counsel involved.
I would agree with that.
So, and the only thing I'd add is that I agree with you guys on whether it's privileged, but I will note that I do kind of like having those reports come to legal counsel, not because I think that they are privileged, but because I'd like the lawyer to have a chance to take a gander at those things, because occasionally you see them start with lines like, you guys are committing fraud, or some other line that I might prefer not to be widely distributed.
These are clearly coding violations.
Exactly.
Should be reported to the government immediately.
Right. And so as a chance, really not because I think it's privileged, but because then at least before it's widely disseminated, you might get a chance to edit it, which I guess that's just totally different from whether it's privileged.
Yeah, I think it turns on a kind of a potentially subtle question, which is the work being done, is the review being done so that the lawyer can provide legal advice for the company? Is that the purpose of the work that's being done? Or conversely, is the lawyer just simply looking over the work before it goes out the door so that the lawyer, he or she, can give advice about how it looks before it goes out the door? Are they just editing something that you would be doing anyway? The whole audit may not in that instance be for the purpose of giving legal advice. On the other hand, if there's a lawyer who's involved because you've got an issue that you really need to dig into in the organization and kind of figure out how to advise the company on what to do or the hospital on what to do, then I think that's a different kettle of fish, and then I think that can be.
Well, this may segue right into the next point where you guys taught me something recently that I certainly wasn't aware. There's sort of the distinction between attorney-client privilege and work product. And so, Dulcie, maybe you can talk about that a little, and I can explain what you guys schooled me on.
Yeah, so we talked about the difference between work product protection and attorney-client privilege, and so there's different rules that apply to each one. Attorney-client privilege is what we typically talk about when we're talking about privilege, and the basic rules for attorney-client privilege is that first of all, it must be a communication between employees and the company's attorney for the purpose of giving or receiving legal advice. So that's that's the bottom line requirement for attorney-client privilege to apply. Now, some courts will extend the privilege to non-lawyer investigators who are working under the direction of an attorney. And this is, I think, generally the main rule that's applied in most jurisdictions. There may be some variation depending on what state you're practicing in, but for the most part, if an attorney is retaining help either from an inside investigator or from a consultant, an expert consultant, for example, a coding expert or an accountant or somebody with expertise, and that expertise is being provided for the purpose of giving legal advice, then communications between the client, between the company employees and that person could be and typically would be protected under privilege if some of these other requirements are also met, and I'll get into that in a second.
Well, and this is where my education was, because I have historically thought of work done by attorneys as attorney-client privilege. Work done by non-lawyers is covered under work product privilege. And you're going to talk in a minute about some of the distinction, but the biggest one of which is work product is only protected in anticipation of litigation. And so I thought, basically, if it's done by a non-lawyer, it has to be in anticipation of litigation. And what I hear you saying is that is not true.
Right. If that person is acting under the direction of a lawyer and the whole purpose of that person's work is to provide legal advice to the company, then most courts would extend privilege to that communication. And this comes up all the time in transactional settings. There's never anticipation of litigation when you're selling a business or doing some sort of contract or a deal, but a lawyer may need the advice of an expert, maybe somebody, an evaluation expert in connection with that deal. The communications with that expert would typically be considered privileged. The second requirement, though, also has to be met. So all these bullets are requirements. The information must involve matters within the scope of the employee's company duties. So, for example, if there's an interview with an employee about his or her drug abuse outside the office, that is outside the scope of the employee's duties, that probably would not be a privileged interview. And it's not privileged if the investigator fails to explain that the legal department is overseeing the inquiry. So the employee who is being interviewed must be aware that the purpose of the interview that the employee is participating in, the purpose of the communication, is to facilitate legal advice to the company. If they're not aware of that, it's probably not a protected communication. And then the communications must be designated as confidential when made and must remain confidential. The employee participates in an interview and then goes out and blabs about everything that's said about it, then the privilege may be waived. A couple of important caveats that I think people often get confused about. One, the privilege does not protect the disclosure of underlying facts. So if you're investigating an employment issue, Dr. X harassed Nurse Mary, okay? Maybe that's the employment issue that's under investigation. The fact that Dr. X harassed Nurse Mary on July 5th wouldn't be protected. However, what the employees who are being interviewed about that, the witnesses to that incident, say to legal counsel in the context of an investigation could be protected as privileged. And the privilege does not protect non-lawyer management communications with each other about the investigation. A good example would be the CEO and the CFO are talking to each other and they say, wow, we really can't deal with firing Dr. X right now. He's he's our only neurosurgeon, and it would be really bad for the financial health of the hospital if we fired him. So we don't want the investigation to turn out this way. That would be something that wouldn't be protected. And so if that ends up in writing, then that could be something that would end up being disclosed no matter how hard you try to protect the privilege.
So Dulcie, what if I just copy legal counsel on this? If the CEO, while sending that to the CFO, just tosses in a CC general counsel?
Right. Just copying a lawyer on a communication does not make it privileged. Go back to point one. The purpose of the communication must be to either facilitate the lawyer giving legal advice or a communication from the lawyer for the purpose of giving legal advice.
So that leads us to talk about the other protection, the work product doctrine. This really isn't really technically considered a privilege. This is a court-developed doctrine over time that helps protect, attorney work product that can be, from being discovered in litigation. So work product, the main points here, this doctrine applies to memos and work product created by or at the direction of company attorneys, either inside or outside. So that's not going to include materials prepared or exchanged by employees or consultants who are not acting under the direction of an investigation counsel. It also includes only documents that are prepared in anticipation of litigation, and David already raised this point. The question is,
What is anticipation of litigation? That's a very complicated question.
So yeah, so Lucine, you and I have worked for 4 years on a case that before I took a hard right was kind of this question, right? So I know that E&M audits happen all the time. Is every one of those I do done in anticipation of litigation? What do you think?
Well, no, I think, I mean, I don't think, a typical E&M audit, you could argue would be anticipation of litigation. I mean, I think in the broader sense, you could try to argue everything you do in a company, someday there could be litigation involving or over it. But that is not what a court, is going to look at when it's deciding if you get to claim the work product protection over something. The court's going to be looking to see if you really had a reasonable anticipation and knowledge that some litigation was actually coming. That there was some kind of investigation or there was some kind of a threat of litigation that you became aware of before you can try to claim that doctrine. And that's a hard line. But, I would say once you've received a subpoena or civil investigative demand from the government, you have a pretty, good claim that you think that litigation could be anticipated at that point. This is weaker than privilege. So privilege, is pretty much sacrosanct if you can show the elements that Dulcie had discussed on the previous slide. But the work product doctrine can be overcome with a showing of what, quote, substantial hardship. So if you're in a court battle over whether it applies, the court decides this is the only way the other party can get this information and it's very important, it may overcome the work product protection. So then there's also another thing I wanted to mention was that there's greater protection for attorney opinions or mental impressions. That's really what this doctrine was created for. So to the extent you're trying to protect memos or interview reports and there is actually attorney opinion or mental impressions contained in those, that your argument is much stronger in that context.
So does that argue for if you're doing an interview summary, throw in your impressions?
Well, yeah, Dulcie and I, when we do interview summaries or, we're directing somebody else who's another lawyer at our firm who's doing interview summaries, we ask them to include a phrase in them, towards the top that says this is not a verbatim recitation of the interview, but it actually includes attorney impressions of the same. And that, is something that will be a signal to any court that's reviewing this in the future that, this is really something we intended to be creating under the in anticipation of litigation and under the review of the lawyer. So then we wanted to talk also about where protections apply and where they might not. And this is something that's important to learn as well. I'll summarize this briefly here, this slide, because the main point here is that different states have very different views of what the test is to determine whether or not privilege applies in the context of a company or corporation or business. So in some states, there's this thing called the control group test. And that test says the privilege extends only to persons in the organization who are in a position to control decisions that are made after receiving advice from counsel. This is kind of the old test from way long ago that still survives in a few states like Illinois, Maine, Hawaii. There are a few others. But it's important to know that because, obviously if you're including on communications in your investigation all kinds of people outside a control group, and you're in a control group state, you're not going to have a very good argument that privilege is going to apply to those. So the majority of states have what's called the subject matter test, and that's a little, protection is a little broader there. And in that case, the privilege is going to apply to any employee if they're discussing a subject matter, if they're discussing the subject matter of legal advice to the company. So that's a little bit broader test, and it's not limited. The employee doesn't have to be somebody in that control group. Other states apply neither of these approaches. In fact, Minnesota has the Minnesota Supreme Court here has actually advocated for a sort of combined test between the two of them, and there are a few other states who have slightly different standards that haven't evolved along this line. And then just I don't know how many of the folks listening online this would even apply to, but foreign law has some countries, especially civil law countries, have an extremely different approach to privilege, and they don't recognize attorney-client privilege per se at all, but they may recognize some other general duties of confidentiality against, in their codes that govern lawyers and what lawyers are responsible to do.
So Lucy, we've got we have Quad Cities listeners on today, right? Host of people so you're in Iowa and Illinois.
Yeah.
And you've got an investigation that you're doing one part of the thing in Davenport and one part in Rock Island.
Yeah. Well, it's a measure of risk and what the court's going to think when it's analyzing your case and you're claiming privilege. My advice would be to try to stick by the most strict approach in that case. Because if you're going by the control group test, I would say you're most likely going to be meeting the subject matter test, but you're going to want to make sure you're paying attention to both of them when you're in your communications and that you're considering that when you form your team to do the investigation and when you're making those communications.
Thanks.
Also important to evaluate whose communications are protected and whose aren't. Now, Lucine just talked about the control group test. As we've been explaining, it really varies on which court has the case. Is it federal? Is it state? What state is it in? Is there a foreign jurisdiction issue? All of these things could bear on whether something is protected as privileged or not. And who you're talking to becomes critical depending on what jurisdiction you're in. There's also a question as to whether former employees of the company, so you're doing a broad investigation into some allegation that involves some folks who have now left and you need to talk to those people. Whether or not those communications with former employees can be protected by privilege really depends on where you are to a significant degree, because there are big splits in state law on this. In the state of Colorado, it's very clear privilege does apply if the question at issue, if the communication is about matters within the scope of that employee's employment. But since 2017, there's a case that came down in Washington State that said that privilege does not apply to former employees. And so it really matters where you are. Another issue to consider if you're talking to an employee or a former employee is what is that individual's position with respect to the matter that's under investigation. If that person is really the target of the investigation, let's say you're investigating Dr. X's sexual harassment of a nurse, the adversity of Dr. X in that circumstance may make a court decide that's not a privileged interview. The presence of individual counsel on behalf of Dr. X in the interview, if he says, I want to bring my own lawyer, that's probably not a privileged communication. So there are considerations as to who you talk to and whether it can be privileged or not. We already talked about consultants and advisors. If somebody is
actually, I want to go back just to highlight
okay.
what you just said.
Yeah.
I mean, so
right.
Sometimes employees want to bring their own lawyer.
Right.
And so just because I think that could, so there's a ramification to that.
There is a ramification to that. I mean, typically if they're kind of in an adverse position and they have their own lawyer with them and they're kind of on the outside, then it's really going to be hard to argue later that what you've talked about in the context of that discussion is a privileged conversation. And then
could you cure that with a joint defense agreement?
Potentially, yeah. But there would have to be a common interest, so that goes back to the adversity question. Just because they have a lawyer there wouldn't necessarily, and that's sort of going to the last bullet point. And we should maybe explain to some of the members of the listening audience what a common interest agreement is and what that's about. If multiple parties on the same side of litigation or an investigation share a common interest. So a sort of common example is, let's say a hospital is being investigated for Medicare fraud and 5 of the doctors are being investigated for Medicare fraud. And they're really all on the same side of the fence. They're all trying to prove that no fraud occurred. Then I would say they have a common interest. If, on the other hand, you are interviewing Dr. X because you believe he stole drugs from the hospital pharmacy, it's much more difficult to argue that you have a common interest with Dr. X because he's really the target of your investigation. And so I don't think in that circumstance that having a common interest agreement will help you, because a common interest agreement isn't going to hold up. There has to be a common interest. The common interest doctrine is something that basically says, okay, privilege normally applies to communications between an attorney and the attorney's client, or the representatives of the attorney's clients, so the employees, the control group, as we just discussed. common interest doctrine is something that's been recognized by the court. So you can extend that privilege to communications with other parties who have a common interest with you. And so what it allows you to do if you have a common interest agreement is to share privileged communications with somebody who's really kind of a third party in the matter without blowing the privilege. So just to put that in clearer terms.
Okay, now we're going to turn to, that was all step one, and really that.
So we're going to go for 5 hours, right?
Exactly. No,
the rest of them are quicker.
The rest of the steps are much quicker. The step one is the most important because it really is important to educate folks, who are doing these investigations about why privilege is important and what it means and how it works in the context. So step two, put a lawyer in the lead is the slide. And actually, we're going to talk on the slide about maybe it's not, you don't always necessarily have to put a lawyer in the lead. And Dulcie referred to this a little bit on an earlier slide, but here's how it's best to look at investigations, is that there's sort of a preliminary inquiry stage where you're maybe you get a report, you do, one or two initial interviews or document reviews to assess, is this really a valid claim? Is this just, some kind of, internal silliness? There are some disgruntled employee who's trying to cause trouble and there's nothing to it and there's no reason to ever call in attorney on it. Or is it low risk for the company, even if it is, something you'd want to investigate further? It's extremely low risk, low cost potential, et cetera. These preliminary inquiries are often led by, it could be HR, it could be compliance officers, it could be other members of management. And so clearly that part of an investigation is not going to be privileged. You don't have a lawyer involved at that point usually. So the next step would be, you've decided you really need to look into this allegation. And that, sometimes with certain allegations, that may be clear right from the start, just for the nature of the allegation. Others, you need to do that preliminary inquiry step. But the formal investigation should really be led by an attorney if you think privilege could be important at all. And this is going to apply in context where, you think there could be a future government investigation. There could be litigation where there's going to be some significant risk to the company. You want to avoid some extreme embarrassment. And, there's a lot of context in which you would think privilege would be important. And you've got to get at that point either in-house or outside counsel involved. I promise this is not self-serving to the audience out there, but the courts really have found that privilege is stronger when outside counsel is involved. For some reason, courts really view outside counsel as having greater independence and fewer potential conflicts. In-house counsel may owe some sense of duty to, other folks in the firm, and they may not be as independent, and, courts may view their claims of privilege with greater suspicion. Also, with outside counsel, there's not going to be this issue of, sort of mixing up business and legal advice usually in the same email, although that can happen as well because outside counsel investigations may get pulled into business issues. But, there's certainly a greater risk of that when you're talking about in-house counsel. And I also raised here too, I don't know how much it applies, but that, outside counsel privilege is recognized more under more foreign laws than it would be to in-house counsel, which a lot of countries' in-house counsel don't have privilege protection at all.
Step 3, make a communications plan and stick to it. I think one of the biggest mistakes that I see lawyers who are investigators and non-lawyers who are investigators making is they launch into the investigation without taking a step back to decide what is the chain of communication going to be for this investigation. It's really important to be clear about who's going to oversee the investigation and to report only to them. And by that, I mean not who's going to lead it, but who is going to receive the reports once the investigation is done. Who are you going to report to with questions about how far, what's the scope of the investigation? Should we add these employees to our list? How far do we go? What do we do about this issue that came up in the middle of the investigation? You need to have somebody to report to. If you're an outside attorney, it's probably going to be either the general counsel of the company or somebody in-house in their legal department, or it could be the CEO, or in some cases it might be the board of directors or somebody, even at the compliance officer, somebody at a different level. It's really important to be clear about who's going to oversee the investigation. Next, I think it's important to identify who's on the investigation team. It should be a small enough team in size to be able to limit the scope of communications, but of course it needs to be adequately staffed. So it could include lawyers, paralegals, IT experts and records management personnel who might need to be called upon to pull together documents. You may also need to put accountants, HR personnel, and other experts with company knowledge on the team. It is critical when you put together your investigation team to avoid using anyone who has a potential conflict of interest. And so one example that I've run into personally is I might be initially asked to report to the general counsel of the company and then find out that the CEO of the company is actually somebody who's had allegations against him in connection with the investigation. If the general counsel reports directly to the CEO, that actually creates a conflict of interest for the general counsel. And at that point, you may want to consider asking to have a special committee of the board of directors to report to, as opposed to reporting to the guy who actually is on the team of directing an investigation against his own supervisor. So it's important to make that communications plan clear from the outset and try to anticipate those kinds of conflicts from the outset. You should take care when non-lawyers are on the team. Team members should report and take direction only through the lead attorney, and that's again to try to establish that chain of communication is protected under attorney-client privilege. Any outside experts that get retained should be retained by the lawyer. It's just easier to prove that that's a privileged communication if the attorney has retained the outside expert. And team members should be directed to segregate investigation materials from their other work. And it's usually better to have attorneys leading the interviews whenever possible, again, because the communication with an attorney could be considered a work product communication if attorney-client privilege fails, but if it's a non-lawyer, you can't make that argument.
Step 4, limit internal reporting. So our next step in preserving privilege deals with internal reporting, and limiting this can be difficult because there are many stakeholders who will want to know what is going on and be in the loop, especially as it affects their jobs, their departments, and so forth. However, when analyzing whether privilege applies, one of the first things courts are going to look to is whether the communications you're trying to protect had some kind of wide distribution. Were you making an effort to limit the communication to need-to-know folks only, or were you widely disseminating all communications to the whole HR, compliance staff, and management staff? Doing the latter will not help your privilege claims. And that, of course, piggybacks right on Dulcie's discussion of making a communications plan so that you're limiting the group of people who are receiving communication. Concerns about internal reporting are especially key in the control group states that I discussed earlier. There you really have to make an effort to avoid disclosure to folks outside upper management. And this is also where, prior education of staff helps. Staff who understand the privilege and the related risks and rewards won't be as unhappy when they're not in the loop about something if they understand the importance of privilege protection. And Dulcie already talked about, company leaders being the targets of the investigation, and that could waive privilege. What about when they suddenly become targets in the middle of an investigation? That's a strange sticking point that we've faced as well. I think both Dulcie and I have. And, in that case, as soon as you find that out, as soon as you become aware of it, that person needs to be segregated off from your team, anybody who now has a conflict of interest. And they have to be taken out of the loop, and they have to be taken off communications going forward. And that has to be a clear line at that point. Now, it's tough sometimes because maybe you don't always want to alert that person right away, and you're going to have to make some important decisions at that point. That can be difficult to make. But finally, I would just say warn recipients against this distribution. At every phone call, you could say, don't repeat anything that's going to be talked about here on email communications. You could say this is not for distribution, or remind people on the team.
Do you have a preference for email over phone over email or anything like that?
Well, email, of course, is preserved forever. And so, privilege applies both to in-person meetings, what is said during them, and to phone calls and to email. But obviously, email is a lot easier to get and find verbatim what the communication was, and, fight about it in a court of law, that I would say to the extent you can limit emails in the course of an investigation and do more discussion directly, I think that's probably better.
So the next step is a pretty obvious one, I think, to most people: cut off the grapevine. This happens all the time. Maybe Dr. X gets put on leave, and the next day everybody's standing around the water cooler talking about what he did and sharing with each other their thoughts on that. This type of conversation can be the bane of any internal investigation and any company that's trying to keep things under control. And it can lead to things like defamation lawsuits. It can put the company's privilege at risk as well, which is why we're talking about it today. I think we are all cognizant of the fact that you can't always prevent people from talking around the water cooler. But there are some things that you can do to try to limit the spread of gossip. One thing that is pretty important is to warn control group employees against discussing the investigation widely with each other, particularly by email, without counsel present. As I said at the beginning, if there's a business issue that's being discussed, if it's not something that really brings in legal advice or is a communication for the purpose of giving legal advice, those email exchanged between the control group employees still aren't going to be privileged. And so it's important to talk to whoever is sort of overseeing the investigation about the need to really keep their own counsel about it, to keep the gossip from spreading. It is also important in interviews to instruct witnesses and document custodians on the need for confidentiality. You don't want to have an interview with the supervisee of Dr. X and then have the supervisee running out and telling everybody what the questions were and assuming that Dr. X did something terrible because you asked him about his harassment of nurse Chatty, and all of a sudden there's a defamation lawsuit coming your way because of that. And so it's good to talk to employees about the need to keep things under wraps. And in addition to that, again, those are not going to be privileged communications. Sometimes, occasionally, and I would definitely not say this is something that you want to do all the time. It's a judgment call on a case-by-case basis. But sometimes it's a good idea to send out a note to employees, particularly when gossip is really rampant, to just say, look, this is under investigation. Prefer that you don't gossip about this with each other. If you have questions or if you have information that you think is important to the investigation about this issue, please refer to whoever the lead investigator is.
What tips? I mean, because from practical, this to me is always one of the toughest things, right? Walk in and saying, "Don't talk about this." Often, hi, you're meeting with a lawyer for the first time in your life. Don't tell a soul this happened, right? That's just not realistic. So, what actual message do you deliver to try to get people to focus on that? Because they're clearly, they're going to go home, they're going to talk to their spouse, they're going to. We all know that happens. So what tips do you have to keep people as quiet as possible?
Typically we'll just tell people, and I think, one caveat to the instruction not to talk to people is always, it's always okay to talk to your own lawyer, right? So if the employee happens to be somebody with their own lawyer, I'll say, it's okay to talk to that person. I do tell employees, I would prefer, the company, you are an company employee, it would be damaging to the company for this to be widely gossiped about, and we are asking you not to talk to your spouse about it. And I think employees can heed those instructions and often do heed those instructions, although the last bullet point is critical. You have to know that in every situation like that, some employees are going to talk, and you have to be realistic about that. Sometimes it's good to talk to them about that issue and say, how would this instruction to keep things confidential affect you? Are you concerned about this? Why are you concerned about it? And then maybe you can help guide them to other pathways that they can use other than just spreading the gossip.
And then with the SEC guidance, some of the other stuff is focused on instructions to not talk as being obstruction or preventing, discouraging people from talking to the government. Is there anything you include in that discussion to make sure someone doesn't construe that as a prohibition from communication?
Yeah, right. And I think it is good to be clear about that. For a purely internal investigation, I don't normally give that instruction because it's not necessary. But if there's an investigation that's external where the government is involved, we do try to make it clear. We're not telling you not to talk to the government. You have a right to do that if you want to, we would prefer, if you do decide to talk to the government, that you tell us that you're going to do that, so that then we at least know that that conversation is going on and can maybe talk to the employee's attorney if they have one, or even get them an attorney if they don't have one.
All right, step 6, separate legal and business advice. And we did talk a bit about this already, but since the main purpose of the privilege is to protect communications that are related to the provision of legal advice, obviously, you could water down your privilege protection by mixing business advice and legal advice in the same communications, meetings, or email. And this is the biggest risk for in-house lawyers. It still also applies to outside counsel who may ask to opine on business issues and business risk at the same time as they're giving legal advice. Courts view this different ways is all I can say. Is that some courts have required a clear showing of a legal versus a business purpose. There was a semi-recent case, Acosta v. Target Corporation, where Target was trying to claim privilege over a huge range of materials, thousands of documents, but the court ultimately found that business advice was strewn throughout these documents, and the court had said, it just really had no way of separating those out, and no attempt was made internally to actually separate business from legal advice, and ultimately a number of materials that could have potentially been privileged were ordered to be produced. So the advice there is just give some thought before you email. Both, whoever's on the phone, both in-house and outside counsel, try to send separate emails for big business and legal analyses, even if they're regarding the same subjects. That's not always completely realistic, but if you can at least separate out the legal analysis in your email from the business analysis, and make a note of that part of its communication is privileged, that's easier to redact later when you have to produce this in litigation. Also, even if you're not an attorney, think about that issue when you're emailing your attorney, and maybe you want to send separate emails when you're asking for business or legal advice. And finally, related to this, board minutes should definitely note when discussions are being held with company counsel under privilege. When company counsel is advising or giving legal advice or reporting on an investigation for the purpose of giving legal advice, that should be well noted.
I will just note on that one, Lucy, the time we found that, David Glazer says in the board,
yeah, and a direct quote,
yeah,
and nothing marked out about attorneys. Yeah. All right, step 7, label documents accurately. Investigation reports and memos should always state that the purpose of the investigation is to gather info to provide legal advice and identify any actual or anticipated litigation or government investigations that creating a work product protection that you're trying to claim. But you don't want to over or under label. Labeling every single thing privilege, courts may view as suspect and may say, that's ridiculous, you've labeled every single thing related to investigation privilege. And they may not want to wade through that themselves. So you want to make sure you're accurately using your labels. You can also obviously underlabel. If you don't label it, then the court may be confused about who's reviewing it, may be confused about whether you intended privilege to apply to something at all. And one caveat to be aware of, if you put work product designation on something, you're saying you think it's in anticipation of litigation. And so that could also then trigger document preservation and litigation hold notification requirements. So just be aware of that.
That's a very interesting point, Christine.
Next, we're going to talk about interviews. For folks that don't do investigations all the time, it may seem natural to want to just record what the person says during the interview, because then you have a record of it. Don't do that. If you want to keep the interview privileged, that's the last thing you want to do, because in many, many courts, recorded interviews and signed witness statements are absolutely disclosable, even if this is with an employee and even if it's about the subject of ongoing litigation. It is better to bring a note taker who could potentially testify about what was said if you need to have a witness later. And I would make a point too, because of the need to potentially testify about what was said during an interview. If you don't bring a prover with you, or somebody who can testify about you, and you're the lawyer doing the investigation, you probably shouldn't be the lawyer who then gets retained by the company to do handle the litigation later on, because the lawyer himself or herself who conducted the interview may then become a witness in that litigation. So just a little caveat on that. Our method typically is to bring a note taker or approver who can be sort of the witness if a witness is needed. We talked a little bit about the need to include work product opinion and attorney opinion and advice and reactions in the note. And the corollary to that, interview notes should not read like transcripts. Interview reports shouldn't read like transcripts. We don't want, John said exactly this, Mary said exactly this, because that weakens your work product protection over those materials. You're less able to keep that privileged, and a court may find that that's the same thing as a recorded statement. So it's good to include attorney impressions and opinions in any written interview report, but you should, regardless of how you record the information, you should understand that different courts will view whether a witness interview is privileged or work product protected or not differently, depending on where the judge sits and who the judge is. And so it's always important to anticipate disclosure. Write your reports knowing that they could end up in court. Finally, don't use your privileged materials from prior communications, things that you absolutely know are privileged, to refresh a witness's recollection in an interview, because of the risk that interview will then get disclosed, which could then subject the company to a waiver of privilege over those underlying materials. The next thing to know about interviews, if you're a lawyer, and lawyers who do investigations all the time know about this, there's something called the Upjohn warning that we are required to give. It could be a violation of legal ethics not to give an Upjohn warning. So it's a mandatory warning. Here are the steps of an Upjohn warning. I'm not going to go through.
This is like John was in a hot air balloon when this case came up.
Yeah, very funny. Upjohn was a Supreme Court case that against involving the Upjohn company, and
in the healthcare context, I guess. Right? So continue.
Yeah, there you go. But the underlying purpose of the Upjohn warning is to make sure that the witness understands the lawyer is not the witness's counsel, and but that the witness who's typically an employee or somebody else to whom the privilege would apply, that they know that it's a privileged communication because they are a representative of the company, but not because the lawyer represents them, that the privilege belongs to the company or the hospital or the client, and they have the right to waive the privilege if they want to. So the person who's being interviewed can't prevent that from happening or claim some sort of legal conflict later on because a decision is made later that a waiver of privileges, an intentional waiver of privilege, is going to be made. So this prevents interviewees from mistakenly thinking that the lawyer represents him or her. It's a good practice to give a warning like this, even if you are not a lawyer, even if you are somebody who's leading an interview under the direction of an attorney, because it's important to provide the information to the witness that this investigation is being conducted under privilege in order to keep the privilege maintained. And so these are steps that we recommend taking, whether you're a lawyer or whether you're somebody who is interviewing a witness in an investigation under the direction of the lawyer.
And finally, step 10, use caution when you're disclosing investigation summaries or memos to third parties. Okay, so, I'm thinking in the context of you found out a doctor or nurse has been stealing narcotics or drugs from a company, you're probably going to have some kind of reporting obligations on that, maybe local authorities, probably to the DEA, et cetera. So you're going to want to take care that you don't actually take your interview reports or take a couple of your interview memos or summaries from that and hand those directly over to a government agency. What you're going to want to disclose to a government agency is only the underlying facts. If you do end up disclosing investigation summaries or memos, you could end up in many jurisdictions waiving privilege as to the entire investigation, not just those documents. You could end up waiving privilege as to other agencies and private parties as well. Disclosures to auditors, sometimes, to some extent, some disclosures may be unavoidable, but disclosures to auditors usually will waive privilege as well. And to the extent you can restrict that to only underlying facts, that's ideal as well.
And then
you're
talking about outside financial
Yeah, I'm sorry.
auditors.
Yes, good point. Outside of financial auditors. In the healthcare context, you may have a different conception of who auditors. I'm talking about outside accounting auditors. And then insurance companies, communications with insurers are protected under the common interest doctrine, but you would want to make sure that you're making that clear, and communications with them should be labeled common interest and privileged.
So, Lucina, under the 60-day rule, as you well know, you've got to report and return an overpayment if you discover it within 60 days. If you're writing the letter back to the contractor and you say, our attorney has advised us that we need to refund this money.
Yeah. Well, I think I would just avoid saying anything like that at all. I mean, whether that alone, that phrase alone, would for a court say you've now, waived privilege for the entire investigation. Maybe, maybe not, depending on, how strict the judge you're in front of and how they interpret these rules. But I would avoid in any kind of statement that refers to what your lawyer told you, and definitely not any kind of verbatim quoting or they gave me this legal advice. That would be very bad to put in your letter.
Cool. You've answered a couple of the questions. You kind of worked that into the talk, but there is one here who's seen this for you. You made the point. Can you clarify the significance of how the work product designation might trigger document preservation and litigation rules? And I think the person wants to know first, does that mean it's not privileged, or what's it mean?
Oh, sorry. No. Yeah. Let me be more clear on that. So when you are involved in a litigation, when you first get involved in litigation with someone else, with another company or the government, you're going to issue what's known as a litigation hold because you have an obligation under law to preserve certain documents that would be discoverable in the context of that litigation battle that's coming. And that the standard for that, when that happens, is when did you reasonably anticipate litigation? And then the trigger, the mechanism has been, that's where the court is going to look to see this is where your responsibility began in preserving documents. So if you put work product on something when you're not anticipating litigation in any way, and then later on somehow anticipate, litigation begins related to that, well, somebody could argue that you never complied with your responsibilities to preserve information because you anticipated litigation. You used a work product designation on all kinds of documents that now you haven't necessarily preserved all the information.
So a real-world example of that in the healthcare context, the E&M reviews we're talking about, if you do those under work product privilege, this actually arguably creates a duty for you to keep all those puppies. It's kind of what you're saying. I mean, that's actually something I hadn't really thought about before. It's an interesting...
There's been court cases where people have argued that actually you should have preserved those and all communications related to those if litigation ensues later.
So the last questions came in here, and then we'll get people done in time to go watch England, or as I thought, France, play Croatia. So do you recommend giving the up-down warning? Do you recommend that the up-down warning be provided verbally, or do you want people to sign a document, maybe in blood or something, and have them say, I got this up-down warning?
I prefer blood. No, I'm just kidding. Attorneys differ on this. I've certainly worked in joint defense teams with counsel from other firms that routinely provide these in writing. It's a balance, and it really is a judgment call on a case-by-case basis. If there is a concern that the witness is going to misrepresent what was said in terms of being warned, if you really have a sense that the employee might kind of turn on you later and say, no, I thought you were my lawyer, you're disqualified because you didn't give the proper up-down warning, then you might want to do it in writing. Typically, I don't think it's necessary and can be very kind of off-putting and could potentially prevent the interview from happening at all. If the witness is somebody who is really put back on their heels by the fact that here I am cooperating with your investigation, and now you want me to sign a document. What the heck is this about? And so I try to avoid doing that unless I really feel like there's a compelling need, although I do know lawyers who do them routinely in writing in order to protect themselves. What I do try to do in every instance is, again, have that note taker who comes to the interview document in their notes what was said exactly, in terms of it's sort of an exception to the don't do it as a transcript rule. I really want my note taker to write down the fact that the upjohn warning was given and what was said in that warning.
I want to chime in with an observation here because I've been lucky enough to do a bunch of interviews, sit in with you guys doing interviews, sit in with lawyers from other firms doing interviews, and watch a lot of different styles. And I would say, like, to me, it's important to remember your ultimate goal in any investigation is to get to the truth.
Exactly.
And to get to the truth, you want people to talk. And I think, Dulcie, your point about it being off-putting is a giant deal. Like, there are different styles lawyers can bring to an interview. You can take the lights and shine them in people's eyes and really scare people. And that is an interview technique. I personally don't like it very much because I think it's not a very good way to find out what's going on. I am much more a fan of the Columbo style, which shows my age. But as the oldest person in the room, I'll go with that. And I think putting something in front of someone to sign is just like waving a red flag to be super nervous. And personally, my preferred mechanism in all these things is to say, hey, I'm kind of I may not represent you, right? We have to give the upjohn warning. I'm not your lawyer, but that doesn't mean I'm your enemy.
Right.
And I think, so I'm a fan of the more basic approach. Plus, if you do it every time to everyone, that count, and you've got your prover there. You're in shape.
Right, and I think it can be. If you look at it, the upjohn warning protects the lawyer more than it does the client, right? And so I feel like I need to protect myself, and I need to make it clear to the person who's there that I'm not their lawyer, so that they don't get confused about that. I have an ethical duty to do that, but getting something in writing, I think, really protects lawyers more than it does the client who's being investigated.
Well, thanks, guys. The voice you just heard was Dulcie, and then Lucine. Thank you guys both for doing this. And,
thanks, David. Thanks for having us.
A couple things. So we got a last question. Hey, was this approved for CCB CEUs? And we have a whole. We get CLE for this. We get HCCA credit. I have to admit, I have a hard time keeping all the acronyms straight. So I know we have HCCA and CLE, and we can kind of help you get it in the various states. If you send an email to Jessie, she can help you work through that process. As I said, I think our next webinar is going to be frequently asked questions. Send us your questions. You can send me an email, just put FAQ in the subject line. I think it's going to be on 8/8, same time, but there's a little possibility it'll move back to the 15th. And then if you thought this was useful, you'll get a link to the recording in the next few days, and you can feel free to send it around. Now, go watch the World Cup. Thanks again, everyone, and have a great day.